Good morning, ladies and gentlemen. Welcome to Law Sessions. My name is Samuel Senyonjo, and today I'm going to be handling another element that makes a binding agreement. So we are still actually under Section 10 of the Contracts Act, and I'm dealing with what amounts to an agreement. Which elements must be there in order for us to say that it is an agreement, in order for courts to conclude that there was an agreement. So today I'm handling intention to be legally bound. Intention. So that is Section 10. Let me read Section 10. Agreement that amounts to a contract. A contract is an agreement made with a free consent of parties with capacity to contract for a lawful consideration and with a lawful object, with intention to be legally bound. So I'm handling intention to be legally bound. It is very interesting. It is very practical. You're going to enjoy it. So I'm going to ask questions. Number one, are all agreements contracts or not? So these are the questions we are going to be handling today. One, are all agreements contracts? If not, why? And what amounts to legal relations? And what is the test the courts use to determine that there was intention to create legal relations? So, question number one, are all agreements contracts? Do they amount to contracts? The answer is no. Why? Because some agreements are social agreements. Other agreements are commercial agreements or business agreements. So, not all agreements amount to our contract. Some are social agreements, others are commercial or business agreements. So, hence, not all agreements amount to our contract. Well, what is intention to create legal relations? The intention to create legal relations is that the parties that are entering into this contract, they are accept to be bound by the agreement. Just in case of any breach, they can be taken to courts of law and they are liable. So, intention to create legal relations is very crucial. So, to separate a contract, a legal contract from other contracts, there must be intention to create legal relations. You must accept to be bound by that agreement. You must accept to be bound so that in case you breach the agreement, I can take you to courts of law. But if you do not accept to be bound by the contract, then there can never be intention to create legal relations. So, intention to create legal relations is what differentiates a contract from other agreements. We may have many agreements. Let me give an example before we go further. If I called my friends at home that come for a dinner, probably, and due to unforeseen circumstances or happenings, I cancel the dinner, they cannot take me to courts of law that I breached the contract. No, why? Because that was a social arrangement. It was not intended to be legally bound. I cannot be taken to courts of law. Why? Because it was a social or domestic arrangement or agreement. So, in order for any contract to be called a contract, there must be intention to be legally bound. Both parties or all parties to the agreement must accept to be legally bound, such that in case of any breach, they can be taken to courts of law and justice is done to the other party. Wow, that is intention to create legal relations. So, if you've not given any consideration, I discussed consideration, that the loss you suffer, the detriment you suffer, and on the other side, the profit they gain. If you are not losing in any way, if you're not given any consideration, if you're not given in anything, then you cannot say that you were supposed to be legally bound. Because you've not given any consideration, you don't expect to get anything from the agreement. So, intention to create legal relations must exist as an element according to Section 10 of the Contracts Act. such that in case of any breach, I can take you to courts of law. I'm sure we are very clear about that. So now, why is it that not all agreements amount to contracts? Because we have two types of contracts. I mean agreements, actually. We have social stroke domestic agreements, and number two, we have commercial or business agreements. Social agreements. I'm going to begin with social agreements. Social agreements do not amount to a contract. I'm going to give a variety examples of those social agreements. For them, they do not amount to what we call a contract. Well, social agreements, in the case of Bloomer versus Bloomer versus Palmer. Bloomer is BROOMER versus PALMER. It is a case of 1942. Lord Green in that case held that if there is no consideration given, it cannot amount to a contract. It is a social arrangement, a social agreement. So, and he went on to say that law does not impute intention to enter into legal relations where circumstances and the conduct of the parties negate any intention of the kind. So where the conduct or the intention of the parties to the agreement negate or refute any intention to create legal relations, then law cannot impute it on them. If we entered any arrangements, me and you, and yes, as I've said, the arrangement is about you coming to my place to have a dinner. But then, I'm unable to organize that dinner. Even if you come, you cannot take me to courts of law that, hey, look here, Samuel, you breached the contract. No, it is an agreement. There was no intention to be legally bound. So that is what we call legal relations. The court cannot impute it on these persons if their intention negate that fact. If the intention of the parties negate the fact that they wanted to be legally bound, then you cannot impute it on me. What does social agreement entails? I'm going to give a variety of examples about those social agreements. And they range from friends, families, workmates. If you have some arrangements at home, that is a social arrangement. If I have with friends, that's a social arrangement, and probably the people I work with. So it ranges from family, friends, workmates. We have an agreement there. We are not intending it to be legally bound. So the general presumption is that all social agreements are not intended to be legally bound. All social agreements, all social arrangements are not intended to be legally bound unless the parties intended otherwise. Court may rebut the presumption. So it is only after parties intended otherwise that the court may negate it, court may run away from it. But all social arrangements are not intended to be legally bound. The agreement between husband and wives living together as one household are presumed not to be intended to be legally bound unless the agreement states the contrary. So if you're my wife, we are living together, we've had some arrangements or some agreements, we are not intended that if I fail to provide, that you are going to take me to courts of law. And that is the holding in the case of Balfour. Listen to this holding. Balfour versus Balfour. Balfour versus Balfour. Balfour is B-A-L-F-O-U-R versus B-A-L-F-O-U-R. It is a case of 1919. Close the brackets 2 KB at page 571. So, what happened in this case? The husband promised the wife that I'm going to be giving you $30 every month. That was a lot of money in 1919. That I'm going to be giving you $30. But then the man failed. In the process, he failed. He couldn't make it. He couldn't provide the $30. every month he was supposed to provide for $30, but he failed in the process. So after they separated, the woman sued the man for having failed to fulfill the promise. So the judge held that that was a social arrangement. You had not given in any consideration. It was not intended to be binding. It is a social domestic arrangement. Wife, husband. You cannot sue your husband for the same. But it is a case-to-case basis. I'm going to give you cases and you're going to conclude. So, that was the holding in that case, that your wife, his husband, he was your husband. It was not meant to reach this way, to come to court, because it was a domestic arrangement. It was a social arrangement. You are not supposed, you never even given in any consideration. So they concluded that agreements between wives and husbands, in most cases, the presumption is they are intended not to be legally bound. Hope we are clear. I'm handling elements of a contract, and I'm handling Section 10 of the Contracts Act. The last part says the agreement must be intended to be legally bound, to bound both of you. That is number one. That is example number one. Husband, wives. The number two, the presumption against contraction does not work where the spouses are not living together. This presumption, the presumption I've talked about, that all social arrangements are not intended to be legally bound or to end in court. It doesn't work where the husband and the wife are not living together. Now, this is the case of Merit versus Merit. Merit is M-E-R-R-I-T versus M-E-R-R-I-T. It is a case of 1970. Close the brackets. 2. Put 2 in number. And then all, you write A-L-L-E-R at page 760. In this case of Merit versus Merit, what happened? They entered into an arrangement or an agreement. It was between a wife and the husband. And in this case, the husband was supposed to pay $40 for maintenance to the wife. And the wife was supposed to take care of the mortgage. And they made an agreement, a written agreement, to the effect that if the wife finishes the mortgage, to pay off the mortgage, the property was to be transferred in her name. So after the wife fulfilling that one, after the wife paying off the mortgage, the husband refused to transfer the property to her name. So the wife sued the husband for having failed to fulfill the promise. This was the holding of the case. And that I can conclude it is a case-to-case basis. This was the holding. That, yes, though these were husband and wife, but number one, they were separated. They were not living together. That is number one. Number two, there was a written agreement. Agreement was written. It was written somewhere. And number three, there was a consideration. This wife paid the consideration. And then number four, the court held that indeed there was intention that these parties could be legally bound. So this wife, husband, but they are separated. They are not living together. The wife pays off the mortgage. And the man had promised earlier on to transfer the property to her name. But the husband refused. She went to courts of law, sued the husband. And the property, the man was forced by the court to transfer the property to the name of the wife. So you can differentiate Balfour versus Balfour and this case of Merit versus Merit. Balfour, they were living together. But the wife had not paid in any consideration. Besides, it was not intended that the same could be legally bound. So, in this case of Merit versus Merit, they were not living together, and the wife paid in certain consideration. And actually, there was a written agreement to that effect. So, what I'm saying, it is a case-to-case basis. But those are social arrangements. Those are social agreements. So, another example. If a social agreement will have serious consequences to the parties, this may rebut the presumption. If it is going to have an effect, a lot of effect, a serious one, consequence to one of the parties, then the presumption that all social agreements or arrangements are not intended to be legally bound is going to be waived. The court is not going to rely on that presumption. Like in the case of Turner versus Turner, T-A-N-N-E-R versus T-A-N-N-E-R. It is a case of 1975, volume 1, weekly law report. You put W-L-O-R at page 1346. So what happened in this case? The case of Turner versus Turner. These two persons were cohabiting. They were not married, but they were cohabiting. You know those things of cohabiting. You are staying together. You are not wedded, but you are staying together. You have children. So they were wedded. Man was wedded to the wife. And the man promised the wife that I'm going to give you the house after a certain period of time. I'm going to give you this house for it to be yours and your children. So years passed by. The wife left the rental. She was renting. So she left the rental and came in this house with the children. But after, the man chased him. Not like chasing him, but he couldn't fulfill the promise of giving her the house. But she has children. She has been there for so many years. She left the rental, so she's in this house. And the man is telling him, no, I'm not going to give you the house. The woman sued the husband in courts. Sued the husband for breach of the promise. So the court held that the wife was supposed to pay. I mean, the husband was supposed to fulfill the promise. He was supposed to give the house to the woman. Why? Because it was going to cause a lot of problems. It was going to cause a lot of serious consequences to the wife. I've been here for so many years. I have children. I had my rental. I left the rental because of your promise, and now you are saying you are not going to fulfill the promise. So the court granted the house to this wife. So that is example number 3. Then example number 4. Agreement between children and parents are not binding. They are not intended to be legally bound. If you are my son and we make an agreement, even if not written, but if I tell you about something, and I don't fulfill it, then you cannot go to courts of law. That is the case of Jones versus Padavaton. The case is Jones versus Padavaton. It is a case of 1969. You close the brackets. Volume 2. All England law reports. You put ALLER at page 616. What happened in this case? The mother promised the daughter to take her further with education. The daughter was living in the US and the mother was living in London. So the mother promised the daughter that if you join me in London, I'm going to take care of your further studies. The daughter was studying law and she wanted to be a barrister in the US. So the mother promised that if you join me here in London, because the cost of living was very high in the US. So she told the daughter, please come here, I'm going to take care of your education. But then, thereafter, the lady couldn't make it. She couldn't make it. She couldn't fulfill the promise of taking care of the education of the daughter to finish the low cost. So the daughter, you know white's daughters or persons, so what the daughter did, she sued the mother for failure to fulfill the promise. So court held that that was a domestic arrangement between a mother and a daughter, between a parent and a daughter. So you cannot enforce it. It was a domestic arrangement. It was not intended that it should be legally bound. No, it was not intended so. So the court held in the favor of the mother. That is a social arrangement. Hope we are clear on that. That is another example. So, and lastly, about the friends. If it is between friends and friends, the best example I can give is that even if you called us at home and probably things go badly, I break the glass or I break any other thing in your house, you cannot find me liable. Why? Because it was a social arrangement. Oh, number two, if it is not like that, if I called you, you came, but then I failed to organize for that party we had talked about, then you cannot take me to court so that I breached the contract. So those are examples of social arrangements. What is the test? Well, if you go to courts of law, what is the test? The test. The courts is going to use what we call the objective test, the reasonable man's test. If in such a situation, what would a reasonable man say? So what is the test courts use in order to ascertain that there was intention to create legal relations? The courts are going to use reasonable man's test or objective test. Like in such circumstances, the facts as they are presented to court, what would a reasonable man conclude? What would a reasonable man hold? The reasonable man would hold that there was intention to create legal relations, or the reasonable man would hold that there was no intention to create legal relations. So it is a case-to-case basis, and the courts of law are going to use reasonable man test. Reasonable man is test. What would a reasonable man conclude in such a situation? The reasonable man would conclude that there was intention to create legal relations. So he presents the facts before court or before the panel of judges of the jury, and the jury is going to look into your facts, and then they will have a conclusion that, wow, there was intention to create legal relations, or there was no intention to create legal relations. So that is the test. And then number two, business. I told you we have two types: business contracts and then social contracts or domestic. So now in business contracts, the presumption is that all business contracts or commercial contracts are intended to bind the parties, are intended that they are legally bound, that in case of anything, in case of any breach of the contract, they are going to take you to courts of law. So you are bound. So the presumption under business is that parties are intending to create legal relations. It is not any social arrangement. It is intended that it is going to be binding on them. To that effect, you are going to read the case of Rose and Frank versus Crompton, Rose Limited. Rose, the name of Rose, L-O-S-E, and Frank, the name of Frank is F-R-A-N-K-C-O, or company, versus Crompton, C-R-O-M-P-T-O-N, Bros Limited. It is a case of 1925, SC, appeal cases. SC, you put A, capital SC, appeal cases, at page 445. What happened in this case? The defendant is an American company. Then the plaintiff, the one suing, was the was a single supplier to the American company. So the American company made an order to supply, but then before this person had done the supply, the American company has stopped them. They stopped them. In other words, they breached the contract. So when they breached the contract, what happened? They had to go in what was written in the contract. In the contract, it was written that this is not, yes, it is a business arrangement, but there is no liability. There is no liability in it. They used these words: loyalty, friendly cooperation. It is a loyalty-friendly cooperation. It is a mutual one. It is a mutual arrangement. Just in case of any breach, you are not supposed to sue. So, but this person sued. The sole agent for sale of the defendant's paper sued in the US. So when they sued, the courts went to the agreement, the express agreement, and held that this was a mutual arrangement. It was not intended to be legally bound. But the presumption is all business arrangements are supposed to be legally bound. So that is it. In all business arrangements, get to know that there is intention to be legally bound. But now, we need to separate business agreements or arrangements from other arrangements, like mere puff or mere invitation to treat. A mere invitation to treat is not binding. I explained mere invitation to treat. Mere invitation to treat, I'm inviting you to trade. I gave examples. I gave that case of Carril versus Smoke Ball Company. It is a locus classicus case that you need to read about, even if you are offering law or not, even if you have, because it is very an interesting case. This company, there was influenza. The influenza broke out in Europe, most specifically Britain. So when influenza broke up, the company made, the company came up with a medicine called smoke ball. And they said that if any person used the medicine and contracted the influenza, then the company is going to give them 100 pounds. 100 pounds. They went on and deposited 1,000 pounds in bank to that effect. That if you used their drug and still contracted the influenza, then the company is going to pay you 100 pounds. What happened? This Khalil used the drug as prescribed by the doctors, that smoke ball drug. So after using that drug, this Khalil again contracted influenza. So Khalil sued the company. They went to the company, but the company couldn't fulfill the promise. So what the plaintiff did, went to courts of law. That I used the drug as prescribed. I saw the advert and all that, but they are not paying me my 100 pounds as they said. So this is the argument of the company. The company was arguing that, one, that was a mere invitation to treat. That was a mere puff. That was a mere just invitation. We are just inviting the public. Then number two, they said you cannot offer to the whole world. There is no such offer. So we cannot pay this money. We are just, it was a sham. We are just inviting people to treat. So now, this was the holding of the court. The court held that, one, the act of you depositing 1,000 pounds proved that you are serious about the issue. Then number two, the mere fact that this lady used your medicine as prescribed and she had heard about you, the advert, then that amounted to acceptance of an offer. Remember, in order for a contract to exist, there must be acceptance of an offer. If you are offering me, I want to marry you, Samuel, will you marry me? Then I have to accept the offer. Yes, I will. If you do not, if I don't say I will, then there is no acceptance. So the company was arguing that you cannot offer the whole world. Why? Because the whole world cannot accept. But the judge was very, very wise. He laid a precedent. He said, this person used your medicine as prescribed. So that was acceptance. In other words, you can offer the whole world, but that one or two persons who do what you have offered, who do the action, then they have accepted. Then they have accepted the offer. So the court held that that was not a mere invitation to treat. It was an offer. So now I'm saying we need to differentiate between business agreements and mere invitation to treat. And a mere invitation to treat, let me give examples of mere invitation to treat. If you have a supermarket and you display goods, then in the displayed goods, there is written, this Colgate is 5,000. Then it is displayed somewhere. That is an invitation to treat. There is no contract between me and you, not until you get that Colgate, you bring it to the counter, cashier counter, you pay. You bringing it to the counter, that means you are making an agreement. So it is going to be an invitation to treat if it is still in the shelves or anywhere they put. So you need to differentiate a mere invitation to treat and business. So if you go to supermarkets, though that is not an agreement, not until you get their commodity or good, you take it to the cashier. That is the point when the offer is going to be the offer is going to be done, and then after you paying, you've accepted. So we need to differentiate between business agreements and mere invitation to treat. Are we clear? Are we together? I'm hoping we are together. Hope you are together. Number two, there are free gifts. Like if someone is offering a free gift and there is an agreement, that is not business. Let me give an example. We are in a school. I used to perform well in school. And my father could tell me that, Samuel, if you perform well this time round, I'm going to buy you this. But in most cases, he did not. I cannot take him to courts of law that he failed. But that is more social. Let me talk about school. If you're in school and the headmaster or headmistress or deputy promises that any person who gets 4 points or 8 points or 20 points, I'm going to give them this, maybe a car. If that headmaster or headmistress does not fulfill the promise, then you cannot take them to courts of law. Why? It was a free gift. It was a free gift. You had no consideration in it. So there was no intention to be legally bound. Members, I'm handling an intention, and it is an element of a contract, intention to be legally bound. Anything must be legally bound. If it is not legally bound, then there can never be what we call a contract. You must be bound by your contract in order for it to be a contract. That is the difference between a contract and any social agreement. So I can conclude that not all agreements are contracts. Some agreements are just social agreements, and other agreements are business agreements. And the presumption is that social agreements are not intended to be legally bound. Like if I told you, Susie, that, Susie, will you marry me? And then you say, yes, Samuel, I will marry you. And then thereafter, I change my mind because I've seen the other girl. Then I change my mind. You cannot take me to courts of law that Samuel breached the contract. It is not a contract. Why? It is an agreement, yes, but it is a social agreement. So social agreements do not amount to contracts. Not all agreements amount to contracts. Some agreements are social agreements, other agreements are business agreements. and in all business agreements, the presumption is that the parties to the business agreements, are intended that the same should be binding on them. Hope we are clear on that. I've given examples. Parents, son or daughter. If the parents promise their daughter this thing and they do not fulfill the promise, probably the daughter cannot, they can go to courts of law, but they cannot succeed. Why? Because it is a domestic arrangement. If I called my friends for a dinner and probably I do not fulfill, I do not make arrangements, they come and there is no dinner, they cannot take me to courts of law that I breached the contract. No, why? Because it is a social arrangement. Or if they came to my house and they broke a certain thing, I cannot take them to courts of law that they have destroyed this or that. No, why? Because it is a social arrangement. It was not intended to be legally bound. Or if they came to my home, I've organized the dinner, they come and they don't eat. They don't eat. They refuse to eat. I cannot take them to courts of law. Why? Because it is a social arrangement. It is a social arrangement between my friends. So all social arrangement, the presumption is that they are not intended to be legally bound unless the parties or the conduct of the parties proves otherwise. Like that example or the case I've given you between a husband and a wife who entered into agreement that I'm going to be giving you 40 pounds, 40 US dollars every month, and you're going to take care of the mortgage. But after the lady taking care of the mortgage, paid off the mortgage, the husband refused to transfer the property in the name of the wife. The courts of law held that he was supposed to transfer, and actually he is transferred. That is kind of different. Why? It is a case-to-case basis. And the test is reasonable man's test, objective test. It is a case-to-case basis. If there is a constellation, if there is agreement, written one, then the courts of law can conclude that the party is intended to be legally bound. Wow. Hope on intention to create legal relations, we are clear. And there is one other element I want to discuss in 5 minutes. Then I get done with all elements of contract. Tomorrow we are going to begin something new. Tomorrow we are going to discuss the vitiating factors. What can vitiating factors? What can abrogate? I don't know that. What can vitiate the contract? What can abrogate it such that it is not binding on one of the parties? What can make the contract void or voidable? What can make the contract lose that binding force? It is what I'm going to discuss tomorrow. It is very interesting. But now, let me finish up with this other element. Then we shall call it a day. Another element that I talked over, that I want to summarize this morning, is the element of legality of the objective of the parties, the legality of the contract. All illegal contracts are not binding. All illegal contracts are not binding. The only exception is if you didn't know that indeed this contract was illegal. If you didn't know that it was illegal, or if you were forced, or if you are coerced, or if there was misrepresentation, or if there was undue influence, and those things I'm going to discuss in depth hereafter. So, if there was undue influence, but besides that, all illegal contracts are not enforceable. You cannot enforce them in courts of law. Let me give you an example. If we made an agreement that Samuel, you are going to kill for me the other person, I'm going to give you 100 millions. So I kill the person and you don't give me my 100 millions. I cannot go to courts of law to enforce the contract. Why? Because the contract is illegal. That is example number 1. Example number 2. If This is kind of weird. If we made a contract with this prostitute to give me sex, but after giving me sex, I do not pay her, she cannot go to courts of law to enforce that agreement. Why? Because it is an illegal contract. That is example number 2. Example number 3. If we made an agreement, you are supposed to supply me with marijuana and those things, those illegal things, marijuana, Cuba or what, those drugs which are illegal in Uganda. I gave you the money, but you did not supply. I cannot take you to courts of law. Why? To sue you. Why? Because it was an illegal contract. So all illegal contracts, you can think of them, you can give examples as many as possible. We have the penal code. It has those criminal things therein. So most of the criminal things are all agreements to do those criminal acts are illegal agreements. They are illegal agreements. The class begins at 11 every day. It is between 11 and 12:30, between around there. So all illegal agreements are not enforceable by courts of law. Are we clear on that? All illegal agreements are not enforceable. Hope we are clear on that. All illegal, save the exceptions I've given you, you were forced. But if you were forced, there was undue influence, the superior, person of superior rank, forced you to do something, or because of their part they play, because of the part they play in your life, they forced you to do a certain thing. Then that is kind of an exception. But the general rule is that all illegal contracts are not enforceable by the law. If you have any question, you may ask, but I want to get done today all with elements of a contract that are found in section 10 of the Contracts Act. And tomorrow we are going to begin on vitiating factors. Vitiating factors. We are still doing the law of contract. After the law of contract, we are going to do family law. Family law is going to be so interesting. You are going to understand many things about family. It is going to be practical and very interesting as contracts law. So stay here with us. If you know of any law student, tell them about this program. We shall offer to help them. We shall help them out. If you have your daughter or your sister or your brother want to offer law, they're in senior 6 or vacation, they want to offer law, it is going to be so hopeful for them, because in my first semester I wanted to run out of law school. Why? The things, as if they were talking in as if I was watching a Chinese movie with no subtitles. Wow, it was very hard. At a certain period of time I wanted to run out of law school. But if you at least you've had a chance of reading, understanding, people could talk things I didn't know. I never knew even how to cite the Constitution and the provision, the paragraph, and what have you. So I wanted to run out of law school. But if they have this chance in Uganda, it has not been here. Has not been here. Why? Because some of the lawyers are selfish. They are selfish, I tell you. They don't want, even this one, the thing we are doing, they don't want. Some of them don't want. Why? Because they want ignorant person. So you need knowledge. Tell them about this program, that every day from Monday to Friday we are having the program on that very page. Thank you very much. If we don't have any question, if you don't have any question, I want to rest my case. I beg to stop here. God bless you. We meet tomorrow.